The moving truck had been idling for 22 minutes. Loretta Crane stood outside the gatehouse in a blazer and lanyard, smiling the way people smile when they have already decided how something ends. She told me I needed a resident access card, 3 to 5 business days to process. Behind me, a 26-foot truck sat crossways on the county road, fully loaded. My entire life in a metal box, and the entrance it needed to pull through was buried under 2 brick columns, an iron gate, and $180,000 worth of landscaping that had no legal right to exist. I looked at the ground near her left shoe, an iron survey pin, county stamped, still sitting in the grass exactly where it had been recorded in 1963. She did not know what it was. I did. I took out my phone and started photographing the columns, the gate, the survey pin, the HOA placard that read Sycamore Ridge, a premier community. Loretta's smile thinned. "Sir, you need to move your vehicle." I called Wick Ballard instead. "They built on it," I said. "How much of it?" "All of it." He was quiet for a moment. Then, "Do not move that truck." My grandfather Elbert Tyndall bought that parcel in 1949 with cash he would save from 12 years of working other men's timber. 34 acres in Hardin County, Tennessee, mixed hardwood on the upper slopes, cleared pasture running down to a creek that never fully dried up even in August. He did not buy it as an investment. He bought it because he intended to work it, and he did for the better part of 3 decades. He logged white oak, hickory, and poplar, sold to a mill out of Savannah, ran a small sawpit operation on the flat ground near the eastern boundary. It was not a large operation by any measure, but it was consistent, and it was his. And he treated that land the way men of his generation treated things they would earn, carefully, without waste, and with the assumption that it would outlast him. The easement came in 1963. The county had begun requiring formal access documentation for commercial timber operations, a response to a string of road disputes across the region where logging trucks were tearing up shared lanes, and nobody could agree on who owned what. Elbert worked with a county surveyor named Price and recorded a timber access easement across the northern boundary of the parcel, 24 feet wide, defined by metes and bounds. The corridor ran from the county road straight to the interior of the property, exactly where a loaded timber truck needed to go. It was recorded in the Hardin County Deed Index on March 14, 1963, instrument number 4471. That instrument number matters. I have it memorized. Here is what most people do not understand about an easement like that. It is not a permit. It is not a license that expires when the activity stops. A recorded appurtenant easement is a property right. It attaches to the land itself. Specifically, it attaches to the dominant estate, which is the Tyndall parcel, and it runs with that land through every sale, every inheritance, every transfer of ownership in perpetuity. You cannot build over it. You cannot fence it off. You cannot declare it obsolete because the original commercial use has changed. The only way to extinguish a recorded appurtenant easement in Tennessee is through a formal court proceeding, a written release executed by the easement holder, or a specific statutory process, none of which had ever happened with Instrument 4471. Not in 1963. Not when Elbert passed in 1987 and the land went to my father. Not when my father passed and it came to my mother. Not when my mother passed in 2019 and the parcel sat in the estate for 2 years while I figured out what to do with it. Not ever. I grew up on that land. Summers mostly. My parents had moved us to Knoxville when I was 7. We came back every June through August without fail. I knew every trail on those 34 acres. I knew which slopes flooded in heavy rain and which ones drained clean. I knew the creek crossing, the old sawpit foundation, the hickory tree near the eastern fence that had been struck by lightning twice and kept growing anyway. When I left for good at 19, I told myself I would come back someday. That is the kind of thing people say. Most of them do not mean it. I meant it. It just took me longer than I expected. I spent 22 years as a timber contractor in the Pacific Northwest, Oregon mostly, some work in Northern California and Idaho. I knew the business from the ground up because Elbert had taught me the ground-up version before I was old enough to understand what I was being taught. By the time I was in my 40s, I was running crews, managing contracts, reading survey documents the way other people read the newspaper. That last part turned out to be relevant. When my mother passed, I drove back to Hardin County and stood on that parcel for the first time in 11 years. The timber had grown back thick on the upper slopes. The pasture needed work. The creek was where it had always been. The survey pin at the northern easement boundary, the one Elbert and the surveyor had set in 1963, was still there, sunk a little deeper into the ground after 60 years, but right where the instrument said it would be. I decided then that I was coming back, sold my house in Eugene, wound down my contracts, and started the process of transferring the parcel out of the estate and into my name. I knew about the HOA. Sycamore Ridge had been developed on adjacent land in the early 2000s, a subdivision that grew up around the eastern and northern edges of the Tyndall parcel while I was gone. My mother had mentioned them occasionally. Minor friction, nothing serious. They would build their original entrance off the main county road, well clear of the easement corridor. That entrance, I would later learn, had been replaced. Nobody told me that part. The title commitment came back in August 2021. 43 pages. I read all of them. Schedule B is where the encumbrances live: easements, restrictions, covenants, anything that runs with the land and survives the sale. Instrument 4471 was listed on page 9. Timber access easement, 24-foot corridor, northern boundary, recorded March 14, 1963. Right there in black and white, exactly where it was supposed to be. I called Wick Ballard that same afternoon. Wick had been a property attorney in Hardin County for 31 years. He was not flashy. He drove a 10-year-old pickup and kept his office in a building that needed a new roof. What he had was an encyclopedic knowledge of Tennessee property law and a particular dislike for people who treated recorded instruments as suggestions. My mother's estate attorney had recommended him, which was good enough for me. I walked him through Schedule B. He pulled the original instrument from the county index while I was still on the phone. A pertinent easement, he said, runs with the dominant estate. Nobody's filed a release or an extinguishment proceeding. So it is clean. It is clean. Just make sure nothing's sitting on it. That phrase was simple enough that I did not treat it as a warning. I treated it as a checklist item, something to confirm before the first delivery truck came through. I told myself I would drive out and physically walk the corridor before closing, stand in the 24-foot lane, and confirm with my own eyes that it was open and unobstructed. I did not do it. I should have. A single afternoon trip to Hardin County would have told me everything. Instead, I asked my real estate agent. She would mention the HOA's beautification project a few weeks earlier, casually, the way people mention a road paving schedule, like it was routine background noise. I asked her directly whether the project had any overlap with the easement corridor on the northern boundary. She said she would check. 2 days later, she told me the project was on the HOA side of things and would not affect my access. She had not pulled a survey. She had not called the county engineer. She had called the HOA office, asked someone at the front desk, and taken their answer at face value. I should have pushed harder. I know that now. A single afternoon at the county recorder's office in Hardin County, or even a 5-minute phone call to ask the right question, would have told me everything I needed to know before I signed. The instrument index was public record. The permit database was public record. There was nothing hidden here, nothing that required legal expertise to locate. The information was sitting in a county filing system, available to anyone who thought to look. I just did not look, because I had already decided that the professionals involved in the closing process had covered that ground, and I was too busy unwinding a life in one state to take the afternoon it would have required to confirm one item before moving to another. At the time, I was 3 states away, managing a move from Eugene, finishing 2 remaining logging contracts, and settling the last of my mother's financial affairs simultaneously. I made the mistake that stretched and distracted people make. I trusted that the professionals involved had already checked the things worth checking. The HOA's welcome letter arrived that same week. 4 pages. Trash schedule, pool hours, guest parking rules, and on the front page a glossy photograph of the new entrance. Grand columns, iron gate, seasonal plantings along the approach. The letter described the project as a community investment and listed the cost at $1,840. It did not mention the easement. It did not mention the entrance had been relocated from its original position. It included no survey, no site plan, no reference to any adjacent recorded property rights. Wick reviewed the closing documents the day before we signed. He flagged instrument 4471 again in his notes, listed it as a protected appurtenant right, recommended confirming physical access prior to first use. I initialed his memo and signed the papers the next morning. The parcel was mine. The memo sat in the folder. Confirm physical access prior to first use. The project had started the previous October. I pieced this together afterward from county records from a neighbor named Sid Cutler who lived 2 lots down from the entrance and had watched the whole thing go up week by week, and from the HOA's own meeting minutes, which Tennessee law required them to maintain and which turned out to be considerably more revealing than Loretta Crane had anticipated or intended. The original Sycamore Ridge entrance had been built in 2004 when the subdivision was first developed. It sat on the eastern side of the county road frontage, well clear of the Tyndall easement corridor. Nothing elaborate, a pair of brick pillars, a monument sign, some low hedging. It had served the neighborhood without friction for 17 years. In the spring of 2021, Loretta proposed moving it. Her stated justification was aesthetics and traffic flow. The eastern entrance sat at an awkward angle relative to the main road, she told the board, and the approach lane was too narrow for the community's growing volume. A centered entrance would improve curb appeal, signal the neighborhood's quality to prospective buyers, and resolve the traffic angle issue in a single project. She had architectural renderings. She had a contractor quote. She had an answer for every question the board raised at the preliminary discussion. What she did not have was a survey of the corridor she was building into. The board approved the project at the May meeting. 6 members present, a simple majority vote, done inside 20 minutes according to the minutes. Under the HOA's own bylaws, the document that governed every decision the board was legally authorized to make, written notice was required to all property owners with recorded interests in any area affected by construction before work could be authorized. It was a standard provision. It existed specifically to prevent the kind of situation that was now unfolding. That notice was never prepared. It was never discussed in the meeting minutes, never mentioned in the board's email correspondence that later came through discovery, never raised by any board member as a procedural requirement. I was a property owner with a recorded interest in the exact corridor where the entrance was being relocated. Nobody contacted me. Nobody called Wick Ballard. Nobody made the 30-second search in the county index that would have surfaced instrument 44701 and ended the entire project before it started. No variance application was filed with the county. No site plan was submitted for engineering review. The contractor broke ground in late September. Sid Cutler told me he would watch the column footings go in over 2 consecutive weekends. Big pours, the kind of concrete volume that signals something permanent and heavy is being anchored. He walked over one afternoon and asked the crew foreman where exactly the layout was staked. The foreman walked him through the marked positions. Sid said the stakes looked close to what he believed was the old easement boundary, but he assumed the HOA had done the necessary research. He did not raise a concern. He figured Loretta knew what she was doing. She did not. The columns went in 11 feet inside the recorded corridor. The iron gate was hung between them. A landscape berm went up along the approach, ornamental grasses, young maples, a low fieldstone wall built to look established. A security camera was mounted on the right column. A prefabricated gatehouse was anchored on a concrete pad approximately 12 feet back from the gate line. Total footprint inside the recorded easement corridor, approximately 340 square feet of permanent construction. The project was completed in December 2021. Loretta circulated a newsletter with photographs. She called it the most significant neighborhood improvement in a decade. The board named it the Sycamore Ridge Grand Entrance. The county had no construction permit on file for any element of it. No variance, no engineer's plan, no survey amendment, nothing. $178,000 of permanent construction had gone up on a recorded easement corridor without a single county authorization. I moved in the following March. I would hired a 2-man crew out of Savannah to drive the truck. They would done long-haul moves before professional, efficient, no complaints about early starts or tight schedules. We would map the route 2 weeks in advance. The county road approach to the easement corridor was wide enough for a 26-footer with room to spare. I would confirm the road width on a site visit 2 months before closing, walking the shoulder and checking the sight lines from the turn. What I had not confirmed was the gate span. The iron gate between Loretta's brick columns had a clear opening of 14 feet. My truck needed 17. I knew this the moment the driver called me from a quarter-mile out. I told him to pull forward anyway, stop at the entrance, and hold position. I would meet him there. I arrived 8 minutes later. Loretta was already outside. I do not know if someone had called her or if she monitored the security camera feed from her phone, but she was stationed near the gatehouse in a pressed blazer with her HOA lanyard around her neck like a credential she expected to be asked for. Behind her, through the iron gate, I could see the driveway curving toward the interior of the subdivision. My property sat beyond the far tree line. 34 acres I legally owned, accessible through a recorded corridor that was currently buried under someone else's brickwork. She opened with the access card speech. 3 to 5 business days to process. Said it pleasantly, the way you would explain a parking validation system to someone who had never encountered one before. I let her finish. Then I asked her to open the gate. She said the gate opening was 14 feet, and my vehicle appeared to be a larger commercial truck. She said commercial vehicles required advance board approval before accessing the entrance. She said she was sorry for the inconvenience, but rules existed for good reasons. I told her I was not a commercial vehicle. I was a property owner trying to access my own land through a recorded easement that predated her entrance structure by 58 years. Her expression did not shift much, just a slight tightening around the eyes, the kind that happens when someone recalibrates. That access point was superseded by the new entrance design, she said. Residents use the east gate for oversized vehicles. I asked her where the east gate was. She pointed down the road, a narrow, unpaved farm lane running between 2 fence lines. I walked 50 feet and looked at it. 12 feet wide at the opening, soft shoulders on both sides, and a drainage culvert crossing midway that would collapse under a loaded 26-footer without any question. I walked back. That lane will not hold the truck, I said. I am sure it is fine, she said. I looked at the ground near her left shoe. The iron survey pin was sitting in the grass right there, county stamped, set in concrete, exactly where instrument 4471 said it would be, 3 feet from the base of her brick column. She was standing 11 feet inside a recorded easement corridor, and she had no idea. I took out my phone. I photographed the gate, both columns, the landscaping berm, the gatehouse structure, the HOA placard, and the survey pin. I photographed the east lane from the road. I photographed the drainage culvert from both sides. I got a wide shot showing the truck's full position relative to the entrance and a close shot of the column base against the survey marker with a tape measure and frame. Loretta watched me without speaking. I called Wick Ballard. Second ring. I told him what I was looking at. The columns, the gate span, the footings, the survey pin 3 feet from the nearest column base. He asked 2 questions. How far inside the corridor and what type of construction? Concrete footings, I told him. Permanent. He went quiet. Do not move that truck, he said. Leave it exactly where it is and do not sign anything she hands you. I lowered the phone. Loretta had produced a clipboard. A pre-printed form, temporary access variance request, with a signature line at the bottom and the HOA seal in the upper corner. If you just sign this, she said, we can arrange alternative access while the board reviews your situation. I put my phone in my pocket. No, I said. She blinked. I walked back to the truck, told the driver we were going to be a while, and sat on the running board in the morning sun while Loretta Crane stood by her gatehouse and tried to work out what came next. She had no idea what was already in motion. Wick met me at the county recorder's office the following morning. He would already called ahead. Celestine Pruitt had been the senior records clerk in Hardin County for 19 years, and she pulled instrument 4471 from the index before we would fully settled into the chairs across her desk. 1 page, typed on county letterhead, notarized by a woman named Dorothy Ames, whose signature had faded to a pale brown. The legal description was exact, bearing angles, distances, iron pin references, everything a licensed surveyor had measured, and a county official had certified on March 14, 1963. Wick read it twice, folded his hands on the desk. 24 feet, he said. Northern boundary, runs from the county road right-of-way line to the interior of the dominant estate. Celestine nodded. She would already known that. She was waiting to see what question came next. Has any release been filed against this instrument? Wick asked. She checked the index, ran her finger down the cross-reference column, looked up. No release, no extinguishment proceeding, no partial vacation, nothing. Instrument 4471 was exactly what it had always been, intact, unmodified, fully operative. 60 years in the index without a single document filed against it. Wick asked for the HOA's construction permit file next. Celestine pulled up the permit database. Sycamore Ridge HOA. She scrolled through the activity history, a retaining wall permit from 2016, a pool enclosure from 2018, a fence variance from 2019. Those three entries showed an HOA that was at least familiar with the county permit process, that knew how to file, that had done it before. For 2021, the year the grand entrance went up at a cost of $184,000, there was a single entry, a landscaping notification filed the previous August, before construction began, not a permit. A notification, a form that property owners near county road frontage could optionally submit when doing minor exterior plantings or low-impact cosmetic work. It required no structural engineering review, no county approval, no site plan submission, no inspector sign-off. That was the complete record for 2021. No construction permit for the columns, no variance application for the gate or gatehouse, no survey amendment reflecting the new entrance position in the county records, no encroachment authorization from any county office with jurisdiction over recorded easement corridors, no review by the county engineer, nothing filed, nothing stamped, nothing approved. A permanent structure costing the equivalent of a modest house had gone up, and the only paper the HOA had submitted to the county was a landscaping notification that required nothing more than a mailing address to file. Celestine printed the full permit history and the certified copy of Instrument 4471 without being asked twice. Wick requested official certification on both. She produced it. She had been doing this job for 19 years. She had pulled records in boundary disputes, easement fights, adverse possession claims. She knew what we were looking at. She did not say anything unnecessary, but before we left, she looked at Wick and said, "Nobody came in here about that entrance before they built it." It was not a legal opinion. It was a statement of fact. Out in the parking lot, Wick spread everything across the hood of his truck in the November cold and went through the timeline carefully: when the easement was recorded, when the HOA's common areas were transferred to HOA ownership, when the entrance project was voted on, when construction began, when it was completed. Every date documented. Every date telling the same story. A 60-year-old recorded property right that nobody on the HOA's side had bothered to search before breaking ground. "They built a neighborhood entrance on your easement," he said, "without a permit, without a variance, without notifying you, without filing one document with this office. There is no version of this where they had authorization. The only question now is whether they also had a warning before they did it." I asked him what that meant practically. He picked up the certified copies and tapped them against his palm. "It means every element of that structure is an unauthorized encroachment on a recorded property right. It means the county has a code enforcement problem sitting on a county road that they do not know about yet. And when I send Loretta Crane a cease and desist letter this afternoon, every one of these pages goes with it." He paused, looked down at the folder. "I also want to pull the HOA's title insurance file. Any competent underwriter running a standard search on that entrance parcel before the policy was issued or renewed would have found Instrument 4471. It is right there in the index. If they found it and flagged it to the board, and the board proceeded with full knowledge of that warning, then this stops being a mistake that gets cleaned up quietly. It becomes a knowing decision to build on a recorded property right. Those two things are handled very differently." He closed the folder and slid it under his arm. "Let us find out what they knew," he said, "and when they knew it." Wick sent the cease and desist letter on a Thursday. It was 4 pages. It cited Instrument 4471 by number, attached the certified county copies, identified each encroachment element by location and measurement, listed the specific Tennessee Code sections governing appurtenant easements, and gave the HOA 30 days to submit a written remediation plan or face injunctive proceedings in Hardin County Circuit Court. It was the kind of letter that did not leave room for interpretation. Loretta's response arrived 11 days later. 1 page, no attachments, no legal citations. The easement, she wrote, was functionally obsolete. Timber operations on the Tyndall parcel had ceased decades ago. The original purpose of the access corridor no longer existed. The easement had therefore effectively expired, and the HOA's entrance structure was entirely legitimate. She signed it herself. No attorney letterhead, no firm name. just her signature and her HOA title. Wick read it at his desk and set it down without visible reaction. He had practiced property law in Tennessee for 31 years. He had seen this argument before, the claim that an appurtenant easement dissolves when its original commercial purpose ends. It was wrong when people made it in the 1990s, and it was wrong now. Tennessee courts had addressed it directly and repeatedly. An appurtenant easement does not expire because the dominant estate changes its land use. The right runs with the land, full stop. 3 days later, Douglas Vane appeared. Vane was a civil attorney out of Nashville, mid-sized general practice firm that picked up HOA representation work as a steady revenue stream. His follow-up letter was more formally structured than Loretta's, but made essentially the same argument with two additions. First, he claimed abandonment through non-use. The Tyndall parcel had conducted no timber operations in over 30 years, and prolonged non-use, he argued, demonstrated intent to abandon the easement right. Second, he suggested the HOA's construction had created an implied dedication of the new entrance as the operative access point, superseding the recorded corridor by virtue of its existence and community use. Wick underlined both arguments in red pen and wrote a single word in the margin beside each one. Wrong. Abandonment of an appurtenant easement under Tennessee law requires more than non-use, however prolonged. It requires a clear affirmative act by the dominant estate holder demonstrating intent to permanently relinquish the right, something like executing a formal release, filing a vacation, or taking some action that objectively signals permanent surrender of the interest. I had done none of those things. My father had done none of those things. My mother had done none of those things. We had simply not logged the parcel, which was our right as landowners. Non-use without an accompanying affirmative act of relinquishment had been rejected as grounds for easement abandonment by Tennessee courts for decades. The implied dedication argument had even less to stand on. For an implied dedication to function as a substitute access arrangement, the easement holder must have knowingly and voluntarily accepted the alternative through use, written acknowledgement, or some affirmative conduct indicating acceptance. I had arrived on move-in day, found my easement corridor blocked, refused to sign the variance form Loretta handed me, and called an attorney. That sequence was about as far from implied acceptance as the law recognized. The board meeting came 2 weeks after Vane's letter. Loretta had placed the dispute on the agenda under the heading Legal Matters, Tyndall Property. I attended and sat in the third row without speaking. She was composed. Controlled outrage, calibrated precisely enough to move the room without producing anything that could be quoted against her in a deposition. She told the residents that an outside property owner was attempting to force the demolition of the community's grand entrance. She said it represented years of investment and a source of neighborhood pride. She said the HOA had retained experienced legal counsel and was fully confident in its position. She did not mention Instrument 4471. She did not mention that no permit had been pulled. She did not mention the certified county records in Wick's folder. Patrice Homewood sat to her left with a binder, nodding at measured intervals. Two other board members studied the floor. One, an older man named Sid Cutler, seated in the back row, the same neighbor who had watched the column footings go in, caught my eye briefly and looked away. The room voted to authorize continued legal defense of the entrance structure. Loretta thanked everyone and moved to the next agenda item. I drove home and called Wick. File, I said. Wick filed on a Tuesday morning. 2 documents, submitted simultaneously to the Hardin County Circuit Court. The first was a petition for injunctive relief, a formal request for a court order prohibiting the HOA from restricting access through the easement corridor while the dispute was pending. The second was a quiet title action asking the court to reaffirm Instrument 4471 as a valid, unextinguished appurtenant easement attached to the Tyndall parcel in perpetuity. He submitted a discovery request to the HOA the same day. The request was specific. All construction documents related to the grand entrance project, contractor agreements, site plans, permits, survey work, any correspondence with county offices. All board meeting minutes from January 2021 through December 2021. All communications between the HOA board and its title insurance carrier during that same period. And the HOA's full title insurance policy on the common area parcels, the schedule of covered parcels, any endorsements, and any exceptions or exclusions noted by the underwriter at issuance or renewal. That last category was the one Wick cared about most. He explained it to me that evening. When Sycamore Ridge was first developed, the developer would have carried a title policy on the common areas, including the entrance parcel. When the HOA assumed control of those common areas, that policy either transferred or a new one was issued in the HOA's name. Either way, any competent title underwriter running a standard index search on that entrance parcel would have found instrument 4471. It was recorded in plain language in the Hardin County Deed Index. Not obscure, not buried, not ambiguous. I asked what it meant if the underwriter had flagged it before construction started. It means they would have issued a written advisory standard practice when an encroachment risk is identified, Wick said. And if that advisory was delivered to the board and Loretta proceeded with construction anyway, then we stop talking about a mistake. We start talking about a knowing decision to build on a recorded property, right, with documented awareness of exactly what she was doing. That distinction matters in court, and it matters even more for everything that comes after. A good faith construction error, once identified, typically resolves through a cease and desist and a consent order. The HOA removes the structure. The easement is reaffirmed. Costs stay manageable. No one has personal exposure. A knowing decision to build after a written encroachment warning from your own carrier is treated differently. It opens the door to personal liability for board members, subrogation claims from the insurance company, and a paper trail that a judge reads in an entirely different light. While we waited for the discovery response, Wick filed a formal reply brief addressing Vane's legal arguments in writing, 14 pages. The abandonment argument consumed 4 of them. He cited 7 Tennessee cases by name, 3 from the Court of Appeals, 1 from the Supreme Court. Every one of them said the same thing. Non-use of an appurtenant easement, even across many decades, does not extinguish the right absent an affirmative act of relinquishment by the dominant estate holder. The cases were not close calls. They were clean, consistent, and directly on point. I had performed no affirmative act of relinquishment. Neither had my father. Neither had my mother. The parcel had simply not been logged, the owner's right, and nothing in 60 years had been filed anywhere to indicate any intent to surrender the corridor. The implied dedication argument received 2 pages and a footnote. For implied dedication to operate as a substitute access arrangement, Wick wrote, the easement holder must have knowingly and voluntarily accepted the alternative. Acceptance required affirmative conduct, actual use of the proposed substitute, written acknowledgement, or some objective behavior signaling agreement. I had arrived on move-in day, found the easement blocked, declined to sign a variance form on the spot, and retained counsel within the hour. There was no factual basis for the implied dedication theory. Vane's response brief was thin. He restated abandonment and added 1 new case citation, a Kentucky decision involving a commercial license, not an appurtenant easement, from a state whose courts had no authority in Tennessee. Wick noted the inapplicability in a 1-paragraph reply and did not belabor it. The discovery response came in 3 weeks later. Contractor invoices, landscaping contracts, board minutes. Most of it was what Wick had expected. The May 2021 minutes confirmed the project vote. 6 members present. No easement review noted anywhere in the record. No evidence that notification had been sent to any adjacent property owner with a recorded interest. But the title insurance file was different. Wick called me the afternoon it arrived. Russ, he said, I need you to come into the office. He had a specific flatness in his voice, the tone of a man who found exactly what he expected to find and is still struck by how clearly it is written down. How bad? I asked. For them, he paused, bad. Wick had the file spread across his desk when I arrived. He did not open with a summary. He handed me a single page and let me read it without comment. It was an internal memo on the letterhead of Meridian Title Assurance, the HOA's title insurance carrier, dated June 3, 2021, 4 months before the contractor broke ground on the grand entrance project. The subject line read, Sycamore Ridge HOA, Common Area Parcel Review, Encroachment Risk Advisory. I read it carefully. The memo had been generated during a routine coverage review that Meridian conducted when the HOA renewed its common area policy that spring. A title examiner had run a full index search on the entrance parcel and found instrument 4471. The memo described it accurately, a pertinent easement, 24-foot corridor, dominant estate identified as the Tyndall parcel, recorded March 14, 1963, no release on file. Then it said this, Any permanent construction within the recorded easement corridor would constitute an encroachment on a third-party property right and would fall outside the coverage provided under the HOA's existing policy. If the board intended to proceed with the proposed entrance relocation project, Meridian strongly recommended obtaining a written release from the easement holder prior to any construction, or securing a court order of extinguishment through the proper legal channels before breaking ground. The memo had a signature line at the bottom. Loretta Crane had signed it on June 9, 2021. Acknowledged receipt. I set the page down on Wick's desk. He gave me a moment without speaking. She had this 4 months before they poured the footings, I said. Yes. She knew the easement was there. Yes. She built anyway. Yes. I sat back in the chair and looked at the ceiling for a moment. Outside Wick's window, a mockingbird was working through its calls in the parking lot. Oak, the full repertoire, cycling through bird after bird, unhurried. I listened to it for a few seconds without meaning to. There are moments when information arrives and your mind needs a beat before it can organize around the new shape of things. I had come into this dispute assuming bad judgment, assuming that someone had approved a construction project without thinking carefully enough about what the county records showed. That kind of mistake happens. It is fixable if the person making it is willing to acknowledge it. This was not that. The memo reframed everything that had happened since move-in day. Loretta's position that the easement was functionally obsolete, abandoned through non-use, superseded by the new entrance design, had not been a legal theory she would stumbled onto after the fact. It was a story she had constructed to cover a decision she had made deliberately, with a specific written warning from her own title carrier in her possession, 4 months before construction started. She had not miscalculated. She had not relied on counsel who got it wrong. She had read the advisory, confirmed in her own signature that she understood it, filed it in the board's records, and authorized construction anyway. Douglas Vane, I was nearly certain, had never seen this page. Wick produced a second document, a letter from Jerome Okafor at Meridian's Claims Division, dated 3 weeks after Wick had submitted the discovery request to the HOA. Meridian had been monitoring the litigation and conducted an internal review once the encroachment appeared in court filings. Okafor's letter was addressed to Douglas Vane directly. It informed him that Meridian Title Assurance was withdrawing from the defense of the HOA's position. The June 2021 advisory had explicitly stated that construction within the corridor fell outside policy coverage. The board had proceeded with full documented knowledge of that advisory. Meridian bore no liability for the resulting encroachment, would not fund the HOA's defense, and was formally reserving its right to pursue a subrogation claim against the individual board members who had voted to authorize construction after receiving and signing the encroachment advisory. That last clause was the one that mattered most. Subrogation meant Meridian could come after board members personally, not the HOA's pooled reserves, not the community's funds, but the specific individuals who had raised their hands in the May 2021 meeting and voted yes. The people who had approved the project after the encroachment risk had already been identified, documented, and delivered to the board chair in writing. Loretta Crane's name was on the acknowledgement line. Wick folded his hands on the desk. Vane is going to read that letter and immediately think about his own exposure. An attorney who continued arguing a position in court without knowing his client held a signed advisory that directly contradicted everything he was arguing. That is not a comfortable position professionally. I asked what we did next. We take everything to the hearing, he said. The memo, Okafor's letter, the certified county records, the permit history, the board minutes, and every photograph from move-in day. He gathered the file and wrote Instrument 44701 on the folder tab in black marker. Then he slid it across the desk to me. Keep that where you will not lose it. I drove home with it on the passenger seat. The Mockingbird was still going when I pulled out. The injunction hearing was set for a Thursday morning in November. Hardin County Circuit Court. Judge Annalise Bowen presiding. The courtroom was small wood paneling, fluorescent overhead lights, 4 rows of gallery seating that were about half filled with Sycamore Ridge residents who would come to watch. Loretta sat at the defendant's table in a dark blazer, back straight, hands folded on the table in front of her. Douglas Vane sat beside her with a legal pad and an expression I would seen before on men who had recently discovered the ground beneath them had shifted and we're still deciding how to stand. Wick and I sat at the plaintiff's table. He had told me the night before to expect 2 to 3 hours. Injunction hearings in property disputes are not full trials, no jury, no extended witness testimony, just both parties presenting their legal and factual basis to the court, and the judge deciding whether the status quo needed to be frozen while the underlying dispute was resolved. The standard for a temporary injunction was likelihood of success on the merits and irreparable harm. Wick believed we cleared both without difficulty. He went first. He laid it out the way he did everything methodically, without decoration, without asking the judge to feel anything. Instrument 4471, origin, legal character under Tennessee law, 60 years of unmodified status in the county index. Certified records showing no release, no extinguishment proceeding, no modification since March 14, 1963. Survey documentation placing the HOA's column footings 11 feet inside the recorded corridor. Photographs from move-in day, the truck, the gate span, the survey pin in the grass, the column base with the tape measure and frame. The county permit database showing 0 structural authorization for any element of the grand entrance project. Then he submitted the Meridian memo. He handed a copy to Vane, passed a copy to the clerk, and placed the original in front of Judge Bowen. He gave her 30 seconds to read the subject line and the key advisory paragraph before continuing. Your Honor, he said, this document establishes that the HOA's own title insurance carrier identified instrument 4471 in June of 2021, advised the board in writing that permanent construction within the easement corridor would constitute an encroachment on a third-party property right not covered under the existing policy, and explicitly recommended obtaining either a written release from the easement holder or a court order of extinguishment before proceeding. The board chair acknowledged receipt of this advisory on June 9, 2021. Construction began in late September 2021. Judge Bowen looked up from the memo. She looked at Loretta, then at Vane, then back at Wick. Counsel, she said, is this document disputed? Vane stood. Your Honor, no, the document is not disputed. She made a note. Wick continued. Board minutes from May 2021, the project vote, 6 members present, no easement review in the record, no notice sent to the Tyndall estate or its representatives. Okafor's withdrawal letter from Meridian. He noted for the record that the HOA was now defending its position without title insurance coverage and without a carrier willing to fund the defense. When Wick sat down, Vane stood. He opened with abandonment. Same structure as his brief, prolonged non-use. Original commercial purpose ceased. Easement functionally inoperative. Judge Bowen stopped him before the 2-minute mark. Counsel, what Tennessee authority supports the proposition that non-use alone extinguishes an appurtenant easement? Vane cited his case, the Kentucky one. A brief silence in the courtroom. That is a Kentucky decision, Judge Bowen said. Yes, Your Honor, but the underlying principle. Do you have a Tennessee case supporting that principle? Vane looked at his legal pad. He had 3 cases written down. He cited the first one. The judge asked her clerk to pull it. The clerk found it in under a minute. Judge Bowen read the relevant section aloud. It did not support Vane's argument. It cut directly against it. The Tennessee court in that case had explicitly rejected abandonment by non-use in the context of an appurtenant easement on rural agricultural land. The facts were close enough that the distinction was almost uncomfortable. Vane moved to implied dedication. Judge Bowen let him finish his argument without interruption. Then she asked 3 questions in sequence, each one following from the last. Did the easement holder sign anything agreeing to the alternative access arrangement? No, Your Honor, but his conduct. Did he use the alternative access point at any time? No, Your Honor, Did he communicate acceptance of any kind to the HOA prior to this litigation? Not in writing, but... Counsel. She set her pen down on the bench. Your implied dedication theory requires voluntary acceptance by the dominant estate holder. You have told me he did not sign anything, did not use the alternative, and did not communicate acceptance. What affirmative conduct are you relying on to establish that acceptance? Vane had no clean answer. He spoke for another 90 seconds. Nothing he said resolved the question the judge had asked. Judge Bowen called a brief recess. When she returned, she read her ruling from a single handwritten page. Temporary injunction granted. The HOA was ordered to immediately cease all restriction of access through the recorded easement corridor, effective the date of the order. The Tyndall parcel's right of access was to remain unimpeded pending full resolution of the quiet title action. Any further interference with easement access by any HOA representative, agent, or contractor would be treated as contempt of court. She looked at both tables before closing the folder. "I will note for the record," she said, "that the County Building Authority will be receiving a copy of today's proceeding record. The absence of any construction permit or variance authorization for the structures at issue appears to present a compliance matter warranting independent county review." Loretta Crane sat without moving. Vane gathered his legal pad and did not make eye contact with anyone at the defense table or in the gallery behind it. I sat still for a moment after the gavel came down. Wick capped his pen, straightened his folder, and stood without ceremony. He had stood up from this table before. He knew exactly what it felt like when the law performed the function it was built to perform. I followed him out into the November morning. The court order went to the County Building Authority the following week. A compliance inspector named Roy Gaddis drove out to Sycamore Ridge 11 days after the hearing. He walked the entrance parcel with a copy of Instrument 44701, a measuring wheel, and a camera. He confirmed the column footings, the gate structure, the landscaping berm, and the prefabricated gatehouse all sat within the recorded easement corridor. He measured the encroachment distances, photographed each element, and flagged every structure as an unauthorized encroachment on a recorded property right and an unpermitted permanent installation within a county-indexed easement corridor. He issued the notice of violation that same afternoon. The HOA had 30 days to submit a remediation plan and begin removal. Failure to comply would trigger daily fines accumulating from day 31, with the county reserving the right to direct its own demolition contractor and bill the full cost to the HOA. Loretta tried one last move. 4 days after the violation notice arrived, she called an emergency board meeting. I know this because Sid Cutler called me that evening. She proposed an emergency motion to appeal the injunction, a motion to stay the court order pending a full trial on the quiet title action. Her argument was that a $7,400 community investment was too significant to demolish without exhausting every available legal avenue. She needed a board majority. She got 2 votes, herself and Patrice Homewood. The other 4 members declined. One of them, a retired civil engineer named Boyd Greer, who had been quiet throughout the entire dispute, addressed the room before the vote. He said the Meridian memo had settled the question for him personally. The board had been warned by its own title insurance carrier, in writing, 4 months before construction began. They had proceeded anyway. He was not willing to spend another dollar of reserve funds defending a position their own carrier had formally abandoned. Loretta challenged the vote on procedural grounds. Boyd Greer cited the section of the bylaws governing emergency meeting quorum requirements. The vote stood. The appeal was never filed. A licensed surveyor arrived the following week and restaked the full easement corridor. Fresh iron pins at both boundary edges, orange flagging at 12-foot intervals, a stake centerline running the complete 24 feet from the county road right-of-way line to the interior of the Tyndall parcel. The HOA hired a demolition contractor, a different company from the crew that had built the entrance, and they arrived on a Monday morning with a small track excavator and a flatbed trailer. I drove out and parked on the shoulder across the road. I did not get out of the truck. I just watched through the windshield. The iron gate came down first. The hinges were unbolted methodically, the gate panels laid flat on the flatbed. Then the columns. The excavator operator worked carefully around the footing perimeters. He had been given explicit instructions to preserve the survey pins, and he did. The column bases came up in sections, concrete and brick loaded into a debris container. The landscaping berm was stripped back next, the ornamental grasses and young maples pulled and stacked to one side. The low fieldstone wall came apart stone by stone. The gatehouse came down last. 2 men unbolted it from its concrete pad, wrapped it in lifting straps, raised it with the excavator, and set it on the flat beside the gate panels. By 2 in the afternoon, the corridor was clear. 24 feet of open ground, running straight from the county road right-of-way to the interior of my property, exactly as Instrument 4471 had described it since March 14, 1963. The survey pins were visible at both edges. The centerline stakes ran the full length. A property right that was 60 years old was standing in open air for the first time since the previous October. Wick pulled up behind me sometime around noon. He got out and stood next to my truck without saying anything. We watched the last of the brickwork come out of the ground. Neither of us spoke much. There was not a great deal that needed saying. The county followed up 6 days later with the formal penalty assessment: unpermitted permanent construction within a recorded easement corridor, failure to submit required site plan documentation, failure to notify holders of recorded property interests prior to construction. Total civil penalty: $34,000, payable within 60 days. The HOA paid it from reserves. Then the Meridian subrogation claim arrived. Jerome Okafor had been building that file since the day the encroachment advisory entered the court record as a litigation exhibit. The claim named the board members who had voted to approve construction in May 2021, specifically those who were seated when the June 2021 advisory was received and acknowledged by the board chair. Loretta Crane's name was at the top. The claimed amount was $112,000, Meridian's calculation of the costs flowing directly from the encroachment they had explicitly warned against. Legal defense fees, demolition and remediation costs, county penalties, and consequential damages attributable to the access restriction. The board members named in the claim were personally liable, not the HOA as a corporate entity. The individuals. I watched the flatbed pull out of the entrance corridor and head down the county road with $78,400 worth of disassembled brickwork on its deck. Then I put the truck in gear and drove up my driveway. The quiet title hearing was scheduled for February. It never went to trial. Douglas Vane withdrew from HOA representation in December, a letter to the court copied to Wick, citing a conflict of interest he declined to describe in specific terms. The HOA retained a new attorney named Clifford Pratt out of Jackson. Pratt reviewed the entire file, read the Meridian memo, read Judge Bowen's injunction ruling and her explicit comments about the county building authority, and called Wick 2 weeks before the scheduled hearing date. He wanted to discuss resolution. Wick called me that evening and walked me through Pratt's proposal: a consent order formally acknowledging the easement's validity, a recorded agreement binding the HOA to maintain the corridor free of permanent obstruction in perpetuity, and a contribution toward my legal fees. Pratt's opening number on the fees was low. Wick told him it was low. They went back and forth twice over 2 phone calls. The final consent order was filed on January 28th. Instrument 4471 was formally reaffirmed by court order and cross-indexed in the Hardin County deed records against the HOA's common area parcels. Any future owner of any lot in Sycamore Ridge, any future board member elected to that HOA, any attorney running a title search on that entrance parcel from that point forward would find the court's reaffirmation order sitting alongside the original 1963 instrument layered, permanent, impossible to miss or overlook. The HOA was required to maintain the 24-foot corridor free of permanent obstruction in perpetuity and to provide written notice to the Tyndall parcel owner no less than 30 days before conducting any ground disturbance or construction work within 50 feet of the easement boundary. My legal fees were paid in full. Loretta Crane resigned from the board in January, 2 weeks before the consent order was filed. There was no announcement, no letter to residents, no statement of any kind. Her name simply stopped appearing in HOA correspondence, the way a word disappears when you delete it from a document. Patrice Homewood resigned the same week. Boyd Greer was elected interim president at a special meeting. He sent me a short, direct letter, no legal language, no formality, introducing himself and confirming the HOA's intention to comply fully with the court order. I wrote back and thanked him. The Meridian subrogation claim settled privately in March. The terms were not filed as public record, but Wick heard through the regional title insurance community that the named board members had each contributed personally to a settlement fund rather than contest the claim. Loretta's share was understood to be the largest portion. The number that circulated was not small. I do not carry any particular satisfaction about that part of it. She made a decision with complete knowledge of what it could cost her, and the cost arrived. That is not dramatic justice. It is not a story with a moral. It is just how recorded property rights behave when someone decides to test whether they are real. They are real. Spring came late to Hardin County that year. I spent most of March on the pasture, clearing brush that had grown in over the previous decade, resetting fence line along the lower boundary, working on a drainage problem along the creek bank that had been building since before my mother passed. Early mornings, physical work, the kind that does not leave room in your head for much else. I would drive out at first light, work until the afternoon change, drive back. The easement corridor ran open and clean at the northern boundary. The HOA had laid a gravel base over the restaked line as part of the remediation agreement. Good drainage, solid footing, wide enough for any vehicle I would ever need to move across it. Per the consent order terms, they would install a simple swing gate at the county road end, my combination, my access, maintained at their cost. I used it every morning. Beth had put in a kitchen garden on the flat ground near the old saw pit foundation. Tomatoes, peppers, a long row of green beans that climbed faster than either of us expected. She said the soil was richer than anything she would worked in Oregon. I told her Elbert had been composting that ground since 1951. She said that explained it. The land looked the way I remembered it from childhood, mostly. 60 years puts its marks on things. Trees come down, creek banks migrate, fence lines soften, but the bones were the same. The upper slopes held the same morning light. The hickory near the eastern boundary was still standing, lightning-scarred twice over, unhurried, the same tree I had climbed at 9 years old while Elbert pointed at it and told me something I have thought about more than once in the past 2 years. He said a tree that survives being struck twice is not unlucky. It is just well-rooted. I am not a lawyer. I am a timber contractor who spent 22 years reading survey documents because the work required it. Here is what that taught me. When you buy land, Schedule B in your title commitment is not paperwork to skim. That is where the easements live, the recorded instruments, the property rights that survive every sale and bind every future owner. Read them before you close. If you do not understand one, find someone who does. An appurtenant easement does not expire because land use changes. It does not dissolve because years pass and nobody uses it. It runs with the land. It holds against anyone who builds over it, regardless of cost, regardless of board votes, regardless of how confidently someone tells you it has been superseded. Paper beats concrete, every time. Elbert Tyndall recorded that easement in 1963 because a surveyor told him to document his access before someone else's fence made it complicated. He never imagined his grandson would need it 60 years later to move a furniture truck up his own driveway. But he did his paperwork, and it held. If this helped you, leave a comment, subscribe, and share it with someone who owns land.